Good afternoon, everyone. My name is Greg McLawsen. I am the Affidavit of Support lawyer. I help green card holders enforce the USCIS Form I-864 in federal lawsuits, and I serve as a consulting expert in family law cases when the Affidavit of Support comes up in the context of a divorce. Today, we're going to talk about the liability of a joint sponsor under the Affidavit of Support. And just as a preliminary terminology matter, you will see the term joint sponsor used sometimes and co-sponsor used. Those are actually the same things. They have the same meaning under U.S. immigration law. They both refer to somebody who is not the primary visa petitioner. So this is not somebody who has signed a USCIS Form I-130, but rather somebody who is serving as an additional sponsor by signing an additional affidavit of support in a family-sponsored case. Joint sponsors are different from a household member who signs an I-864A. That's somebody who is residing with a primary sponsor or a joint sponsor and has signed an additional contract to make their finances available to that sponsor. I-864As are not what we're talking about here, but actually those folks, the I-864A household members, end up having the same liability as everybody else. So it's kind of an academic point. But for now, let's focus on joint sponsors. So who are these folks? So again, this is somebody who is not the visa petitioner, but who is agreeing to sign an additional affidavit of support for somebody. In most cases, this is somebody with a close acquaintance to the primary sponsor. Usually we're talking about a household member or a friend, but it doesn't have to be. It's any adult U.S. resident or lawful permanent resident residing in the United States. Let's just go over some basics in terms of the joint sponsor's liability first. So by signing the affidavit of support as a joint sponsor, that person is agreeing to assume all of the same responsibilities as the primary sponsor. In law, this is called joint and several liability, but that's basically just fancy talk for saying that a joint sponsor has the same duties under the affidavit as the primary sponsor. So first of all, the duration of the contract is the same with respect to a joint sponsor. There are 5 terminating events defined in the affidavit of support and the associated federal regulations. The 2 that I would encourage you to focus on are that the contract terminates when the sponsored immigrant becomes a U.S. citizen or has obtained 40 quarters of work under the Social Security Act. Note that you will sometimes hear it said that the affidavit of support terminates after 10 years. That is incorrect. The affidavit does not terminate after 10 years. What you are hearing when people say that is a characterization of that terminating event I mentioned a moment ago, which is that the contract terminates after 40 quarters of work. But if somebody isn't working, you aren't making progress towards that 40 quarters of work necessarily. And so it is not accurate to say that the contract terminates after 10 years. There's a separate video on that same channel that you can access to get the lowdown on 10 years versus 40 quarters. Again, the contract terminates only after 40 quarters of work. So as with a primary sponsor, a joint sponsor is entering into a contract which has an indefinite period of enforceability, which is to say a joint sponsor cannot know going into it how long that contract is going to be enforceable. Why? Because the sponsored immigrant doesn't have an obligation to ever naturalize and become a U.S. citizen. And in fact, lots of folks choose to remain lawful permanent residents their whole lives. There's nothing wrong with that. And likewise, you don't know whether or not the person will ever acquire 40 quarters of work under the Social Security Act, because again, that's going to depend on whether they are working and also whether their spouse is earning quarters of work that can be credited with them to them. So in any event, joint sponsor is not going to know how long the affidavit of support is going to last. So that's as to duration. In terms of the legal duties that are assumed by a joint sponsor, there are two primary ones that they need to think about. One is that they are responsible for repaying, excuse me, the cost of any federally funded means tested benefits that are provided to the immigrant during the enforcement period of the contract. That's a lot. Let me break it down a little bit. So, federally funded means tested benefits. There's a set number of programs that fall under this definition. The big ones to think about are Medicaid, food stamps, TANF, which is federally funded cash benefits. If the sponsored immigrant receives these benefits during the enforcement period of the contract, a state or local or federal entity can sue the joint sponsor for the costs of those benefits. So, take an easy example there. If the sponsored immigrant is receiving $300 in TANF cash benefits per month, the federal government can sue the joint sponsor to recover the cost of those benefits. As a practical matter, this is not done in any jurisdiction in the United States that I am aware of. I have heard of one case in the past 5 years or so that was in Colorado, where a sponsor was sued to recover the cost of Medicaid. As a general matter, this just doesn't happen. Now, could that change? Yeah, it could. The Trump administration considered passing a policy that would have required state entities to go after sponsors to recover these programmatic benefits. But this has been in effect since 1997. It's never really been a common practice to go after sponsors or joint sponsors for the cost of means tested benefits. Absolutely, joint sponsors should be aware of that when they consider signing an affidavit of support. But the reality on the ground is, at least right now, that's not something, as a practical matter, that joint sponsors really need to grapple with that much. Different story, however, for the second liability component of the affidavit of support. And that is the following: that either a primary or joint sponsor, by signing the affidavit, promises to provide any financial support necessary to the sponsored immigrant to keep that person's income at 125% of the federal poverty guideline for their household size. So, under 2022 guidelines for a household of one in the lower 48 states, we're talking about roughly $1,400 per month. If the sponsored immigrant's income falls below that level, they may sue the sponsor or the joint sponsor to recover the difference. So if the person is unemployed, they have a federally recognized cause of action to sue the sponsor or joint sponsor for that income equivalent of 125% of the federal poverty guideline. Again, $1,400 per month. What does that mean in the context of a joint sponsor? Well, unlike the obligation to repay the government, this second component of the affidavit of support absolutely is something that does get enforced. So we are no longer talking about hypothetical liability here. This is a real thing, and sponsors truly do get pulled into court for this responsibility under the affidavit. The joint sponsor's liability is, again, joint and several. Remember, that means that it is the same with respect to the sponsored immigrant. So think about the context where a joint sponsor is being asked to get involved in a case. If the primary sponsor has a job that pays over 125% of the poverty guideline, or if they have significant assets that can be used instead of their income, that person doesn't need a joint sponsor. So really, when a joint sponsor has become involved in an immigration case, that means that the primary sponsor, at least at the time when they sign the affidavit of support, doesn't have a lot of financial wherewithal. So what? Well, imagine that down the line, that sponsored immigrant is unemployed and is in need of the financial support guaranteed under the affidavit. Where is that immigrant likely to turn first? Well, maybe to the primary sponsor, but the fact is that person probably doesn't have a lot of financial resources. So if that immigrant has to turn to reliance on the affidavit of support, you can anticipate that it's probably going to be the joint sponsor who is going to be the primary target for collection. Because the whole reason that person got involved in the immigration case was that they were in a superior financial position to the primary sponsor. And as somebody who represents sponsored immigrants, I can tell you that is absolutely the case. That if somebody comes to me and is in need of the financial support guaranteed by the affidavit of support, and that person has a joint sponsor, I know that the joint sponsor is probably going to be the primary target of collections and is going to be a more promising avenue to get the support that's owed under the affidavit. So, joint sponsors are taking a very prominent role in an immigration case when they choose to execute the affidavit. And the reality is that if the sponsored immigrant ends up in a place of financial need down the line, the reality is that joint sponsor is probably going to be the person that the green card holder looks to satisfy the obligation under the affidavit of support. Now, this goes back to the basic law concerning the affidavit, but there is no question in the United States that the affidavit of support is an enforceable contract. And to the same extent that a sponsored immigrant has a right to go after the primary sponsor for financial support, it is also established that they have the right to do so with respect to the joint sponsor. And all of the mechanisms that are specified in the statute in terms of involuntary collection measures that can be had against a primary sponsor, those also apply to a joint sponsor. And that idea, again, of joint and several liability means that it is up to the sponsored immigrant about who they choose to direct their collection efforts towards. So if the primary sponsor is out of the picture and has disappeared, don't know where they are, but you know where the joint sponsor is, then it can be the case that the sponsored immigrant goes directly after the joint sponsor and just doesn't include as a party to a lawsuit the primary sponsor at all, and simply directs the collection effort towards the joint sponsor. I hope this has been helpful to clarify some basics about joint sponsor liability. If there are further general questions, you're welcome to drop them in the comments. I'll do my best to answer each one, or drop by the website soundimmigration.com, and we're happy to answer general questions about liability there. Everyone, have a good day. Hope that's helpful.